with the court's indulgence, I do have a less than 2 minute number of short nano points to make. Just coming back, if I may, on the balance sheet. The most that can be said of the balance sheet approach is that it's one way of doing things. Not taking the balance sheet approach is not an error of law. I think the Upper Tribunal acknowledged as much in its reasoning. We say that the approach taken by the judge in this case was within the realms of rational approaches, and it was adequate for the purpose. I didn't take the court to AH Sudan, which the relevant part is at 122 of the bundle. It's quite a well-known paragraph in Baroness Hale about, again, interfering with expert tribunals.
Yes.
Their decisions should be respected. This is at E. Their decisions should be respected unless it's quite clear that they've misdirected themselves in law. The appellate court should not rush to find such misdirection simply because they might have reached a different conclusion in fact or expressed themselves differently. And we say that's exactly the error that the Upper Tribunal fell into in this case. What I didn't go into, because we didn't go to Warby, we didn't go to all those authorities, I'm not intending to now, but the relevance of that bears on Ms. Dirier's point, which is in order to set aside the facts, the court had to have a basis for doing so. The court had to have a sufficient basis for interfering with those findings of fact and evaluations. We see nowhere in the Upper Tribunal's judgment embarking on whether that was justified. There's just an assumption that there'll be a de novo hearing with absolutely no reasoning at all. So we say that those authorities do have a bearing on Ms. Dirier's point about remittal.
Right.
Sorry?
I said right.
Yes.
Yes.
Yes. And then the last point is just on trauma. I had taken, but not sort of picked out the relevant part of the Mr. Mandelia's judgment. He referred to PTSD at paragraph 54. So he says here that halfway down the paragraph, page 57, I've also had due regard to the opinion expressed by Ms. Lackenby of a significant risk that symptoms of PTSD could re-emerge due to being returned to the source of his traumatic experiences. However, as she accepted in cross-examination, it's difficult to speculate upon what the impact of deportation to Rwanda may be. That might be so, but the risk was there. And where we see him dealing with that evidence, which was set out also in writing, in some detail, where we see him dealing with that evidence, he simply says that he's gained some insight into his mental health and he'll be able to cope. But what he doesn't deal with at all is the impact on those learned skills of being re-traumatised. He just doesn't address it. Those are my submissions.
Thank you very much, Ms. Weston.
Sorry, I waited to see if you had a further question. My lords, my lady, the respondent submits that the appeal should be dismissed, and I'll take my submissions in support of that central position in 3 stages. I'm going to start with the respondent's notice and the additional submissions. We say the judgments below should have been upheld, additional reasons why those judgments should be upheld, and then turn to grounds 1 and then grounds 2. And I will take my submissions in that order, because if you're with me on the respondent's notice point, that has a significant effect on how you approach grounds 1 and 2. Because if you're with me in accepting that, whilst relevant theoretically, rehabilitation is materially incapable of satisfying the 117C6 test, given the other two pillars on which the public interest rests, then the issue on ground one of whether the first tier judge took into account relevant considerations, properly applied 117C6, and properly gave adequate reasons there too, essentially falls away, becomes secondary, because the sole, at least primary point that the first tier judge relied on was a non-starter, essentially. And then it also becomes significant to how you consider Judge Mandalia's rehearing also. In making my submissions on grounds 1 and 2, which will be my stages 2 and 3, I will not be repeating submissions in the skeleton argument because you have them. I'll be focusing on the oral submissions heard today, so you can just have parties' latest back and forth on the issues.
Now, when you said the respondent's notice, you have the final paragraph of your skeleton says submissions in support of respondent's notice. The bundling in this case is so odd. I'm not confident I have seen the respondent's notice.
I think it's in the supplementary
Right.
at 40, yes. And there's actually one point to address in relation to it. It states at section 4, page 41, that it concerns Judge Mandalia's decision. In fact, as the submissions say, the skeleton argument developing this point, it's addressed to both decisions, and I hope that won't be held against me, so I can make the point.
It's simply the single sentence as repeated in your. Sorry, I thought there was a separate document. No,
There is a separate document, but it doesn't say anything extra.
it doesn't say anything more.
No. I think you need an extension of time, though.
If you need an extension of time, I'm sure Ms. Weston doesn't object to your having it. So it's simply that rehabilitation, while a relevant factor, is incapable of constituting a very compelling circumstance.
Yes, so that's what I'm going to start with.
Yes.
If I just be clear, if I may, is that it's incapable of constituting by itself a very compelling circumstance? Or
Well, we'll let Mr. Tabori develop the point. Yes.
So, rehabilitation's relevance is to reoffending risk, and that is, it's trite, is one of the aims, effectively, of deportation. One of the limbs, however you want to put it, pillars, I think is a good way of putting it. When we see that, I won't take you to it now, but the HA Supreme Court judgment at 119, page 306 of the authorities. Yet, as I say, the public interest in deportation doesn't rest purely on the individual's reoffending risk, but on the general deterrent effect and the wider public concern. First authority I do want to take you to is Heshamali and the judgment of Lord Wilson with the majority. It's at tab 14, page 209. So at the bottom of that paragraph, Lord Wilson says, might not the deterrent effect upon all foreign citizens, irrespective of whether they have a right to reside in the UK, of understanding that a serious offence will normally precipitate their deportation, be a more powerful aid to the prevention of crime than the removal from the UK of one foreign criminal judged as likely to reoffend. So that's the first point. And then paragraph 70. Lord Wilson says, page 210 of the bundle, I maintain, so he's referring to a previous judgment of his in OH Serbia, I was entitled to refer to the importance of public confidence in our determination of these issues. I believe that we should be sensitive to the public concern in the UK about the facility for a foreign criminal's rights under Article 8 to preclude his deportation. And then at the bottom of that paragraph, so between D and E, unless it lacks rational foundation, in which case the court should not pander to it, the very fact of public concern about an area of law, subjective though that is, can, in my view, add to a court's objective analysis of where the public interest lies. In this context, it can strengthen the case for concluding that interference with a person's rights under Article 8 by reason of his deportation is justified by a pressing social need.
So what was the first paragraph you cited?
69, my lord. 69, Lord Wilson's having a discussion effectively with Lord Kerr, who's in the minority, and responding to Lord Kerr. Yeah. So I refer to that simply as sort of the highest authority, if you like, for the presence and importance of those other two pillars. I accept, moving on, of course, that in HA Iraq and elsewhere, it's accepted that rehabilitation is, in general, a relevant factor, and that its weight is a matter for the First Tier Tribunal. But for reasons that the authorities show us and that I will give, that relevance is largely theoretical and immaterial. Firstly, because it's just one element, so you take one pillar out and the strong public interest underpinning why there is this scheme in the first place remains present. Secondly, because of the point that we've touched on from RA as applied by Lord Justice Hamblin as he then was in Bin Booga, to which he refers again in HA at 57 to 58, that, and we'll better look at it, the actual words, so I'll take you to those. It's tab 16, and it's page 291 of the authorities. Paragraph 57. Rehabilitation will normally do no more than show that the individual has returned to the place where society expects him to be. So to commend the individual for having not offended, or having even more, because as my friend emphasises, it must depend on this distinction between merely not having reoffended, but positively having rehabilitated, so that more can be said as to future risk. Really just returns the individual to where they are, which is why the difference between not having reoffended as a sort of an absence and, if you like, the positive presence of signs in an expert report, say, of future no risk, are really the same thing. They both amount to saying that there is low risk of reoffending, but the citizen, whether it's one subject to immigration control or not, or the British citizen, is expected to be in that place. So to say that the public interest in deterring such actions or in marking the public societal consternation about this mischief and the need for a system that deals with it, is incapable, the word I'll keep using, of overriding that strong public interest.
Where does the proposition in paragraph 57 of HA stand in terms of its authoritative status? I haven't looked more widely, but here, Lord Hanlon is saying well, that's the proposition, but the Court of Appeal in RA didn't agree with it. And he doesn't then go on to say, but I do, and I'm in the Supreme Court, or anything of that kind.
Oh, my Lord, I accept that point. If we could go back to 55 and the quote from the Upper Tribunal RA, there's the statement, there is, in other words, no material weight which ordinarily falls to be given to rehabilitation in the proportionality balance, which Lord Hamlet says he agreed with in Bin Booga, C56. And then at 58 he says, he notes, as you say, my Lord,
don't the first few lines of 58 really provide Lord Hamlin's view, his answer to 57? Because I think
No real difference.
yeah, well, what he's saying is that it's a matter of weight for the fact-finding tribunal.
Yes.
And it's not right for even the Supreme Court.
yes,
He's saying what weight it should be given. That doesn't seem to say that it can't
no,
exceptionally.
it's absolutely, and
So-
I am incapable, certainly in this court, of overturning that, which is why I don't say it's not, strictly speaking, theoretically relevant, but properly analysed.
It's more than that, isn't it? It's not that it's not theoretically relevant. I mean, it's absolutely undoubtedly capable of being relevant,
Yes,
just theoretically. But also, doesn't that mean in particular circumstances it can be a deciding factor, even when placed against the strong public interest?
well, my lady, I submit.
You say no.
No, and it is effectively the safest place for courts to be in, to say it's relevant, but it's a matter of weight. But properly considered, it's incapable of overcoming the. It's impossible to envisage the scenario in which, certainly in the 117C6 context, it is capable, to use the first tier judge's language, of tipping the balance. And if we go on, for instance, to look at Lord Justice Underhill's summary set out within paragraph 58, we see the same point, really, that he said, where a tribunal is able to make an assessment that the foreign criminal is unlikely to reoffend, it's a factor that can carry some weight in the balance when considering very compelling circumstances. The weight it will bear will vary from case to case, but it will rarely be of great weight, bearing in mind, as Morbic LJ says in Danso, public
Yes,
interest.
it's right, Mr. Boy, you don't,
Apologies,
you don't have to read it
please,
out.
It's just a particularly important sentence because of the
Yes.
point that, because, as he says, this is the point I'm making, because, as Lord Justice Morbic said, the public interest in deportation of criminals is not based only on the need to protect people from further offending, but also wider public policy considerations of deterrence and public concerns. Given that, what's missing only is the consideration of in what scenario can it work? Perhaps a medium offender where the public interest isn't strong and somehow it makes a difference. It becomes a legal fiction almost.
Speaking for myself, I think we would be having ideas above our station if we tried to gloss at the level of this court what is said in HA Iraq 58 and 59. And it's all a bit theological, isn't it? I mean, in this case, it's not simply rehabilitation, it's rehabilitation and delay. Now, and trying to say whether simply on its own the fact of rehabilitation is of no weight, some weight. Surely, hasn't it all been said in HA Iraq 58, including the endorsement of Lord Justice Underhill?
Well, not quite, my Lord, because
You say there should be a further line.
There's
The
a further
line
stage that
being
wasn't
on its
taken to.
own, it cannot, without more, be
Exactly.
determinative.
Exactly. The Secretary of State's case in that for the Supreme Court, I understand, I read it, was trying to establish too much, that it's simply not relevant as a matter of law.
Yeah.
But that's a different point to what I am making. It's that and it's necessary, I say, for you to grapple with this because we see the consequences otherwise. I mean, even at Court of Appeal level before you, in your supplementary bundle, you have reams of OASIS reports and parole board consideration and risk assessment. But it's all just a dead end because in a case like this, an individual subject to indefinite sentence with public protection, how is this theoretically possible issue capable of overriding that, given the public interest engines that are present in that case? It's impossible, and yet a tribunal must hear from experts on this question. The and it arrives as far as the Court of Appeal on carrying the same point. Yet it's a red herring. So unless it's possible to say, here's a way in which, despite this enormous sentence, these terrible crimes, and the sentencing remarks were before you, referring to sadistic violence and so on, and yet the first tier judgment says is enthralled by the sole expert before them, as is perhaps inevitable in a first tier finding forum where they're hearing from an expert. He's complied with his conditions, he hasn't reoffended. It doesn't go anywhere. And I think the Court of Appeal has to give guidance to both to the tribunals below and to obviously the Secretary of State, the initial decision maker, as to the place of this. And simply saying it will rarely add great weight is not enough.
So if we're to say Hamblin got it wrong, and instead of rarely, he should have said, rarely had great weight, it will never have any weight.
Not wrong, taken to its logical next step. That's the position.
I may be misunderstanding, but I don't think you're going. I think you're not going that far. I think what you're saying, per Hamlin 58, it can take whatever weight, but then you can't go all the way without more. So
Yes.
it cannot on its own
Yes.
discharge the public interest,
Exactly.
particularly in a highly serious case.
Exactly. Even in the model citizen, and we've seen the judgment from the first tier, essentially sort of patting the appellant on his head for having complied with.
Just thinking HA, I think you would say, well, in there he'd married, he'd had children, worked as a nurse, so working for the benefit of the community as a nurse, and had rehabilitated and not offended. And would you say those features, family, nursing, would be the bit that would fill the gap of without more?
Yes, to which the additional presence does not assist, it's immaterial. It is a neutral factor. It can be a negative one.
What's the neutral factor?
The rehabilitation element.
I was trying to help you out.
Well, I'm with you, my lady. You've put it better than I have. It's the point that the material ingredients, if you like, would be the points you've identified. It would the presence additionally of he hasn't reoffended, and maybe even here's an expert report saying he's low risk, does not materially add as an active ingredient. And if I could go to my Lord Justice Bean's judgment in Capicania at tab 35. Page 742 of the bundle. Makes the point, you can read it to yourself, my lords, my lady.
What paragraph?
Sorry, paragraph 49. And once you've read that, if I could take you to paragraph 42, the same judgment, or just has been. We see effectively the height of the threshold and what we're talking about to get in the room of satisfying 117C6. If you could read that paragraph to yourself too, in particular the example at the end.
Sorry, which paragraph?
It's 42, page 741. That example is an instance of one of the two ways in which 117C6 can be satisfied by being over and above, namely by complementing, being something that falls outside the exceptions, because the exceptions are narrower than all the ways in which Article 8 can be engaged, and as the example shows, is also at an elevated degree above the threshold of the exceptions. The other way in which 117C6 is satisfied is being simply above, being within the sort of general character of the exceptions, but a level above. And we see a just good description of that in Yalcin, Lord Justice Underhill, tab 30, paragraph 57. Which is, I would sort of recommend as perhaps the best statement of how 117C6 works. But the point I would highlight just for this course of submissions is in the long final sentence.
Paragraph.
This is paragraph 57.
Sorry. Got distracted by the head note.
Please, so as long as you need. Something more will have to be either that the undue harshness would be of an elevated degree, quote, unduly harsh. So it's actually a very good way of putting it. And we see in this case, as we'll come on to in relation to the grounds 1 and 2, well, ground 1 rather, why the perils, as you have explored yourselves, of not having proper focus on the exceptions, because they are your stepping stone, your first rung on the ladder against which the relative concept of over and above can be judged. And given that is our test, how can simply having rehabilitated, which is nothing to do with the exceptions 1 and 2, much less the something more over and above them, ever possibly establish very compelling circumstances over and above either?
I'm just trying to turn over in my mind how rehabilitation might bear on one or other, or possibly both of the other two pillars. And as you've been giving us examples, let me just raise this possibility. If the deportation of the now model citizen, having, let's say, committed an offence which just gets him into the serious category, would revolt the public, then it would be contrary to the public interest to deport, because it wouldn't serve the deterrent effect, it wouldn't serve the reassuring public confidence in the system. It would be an example of the state doing something that offends the conscience of the public. Is that a conceivable circumstance?
I'm not sure it would, my lord, because say a person is just in the category we're talking about, because their sentence was 4 years rather than what we're looking at today, and then they reform and they don't reoffend and they rehabilitate. The factors that that are in play remain there. They weren't given a 4-year sentence because of reoffending risk. Those are subsequent to that. Those are the parole board and Oasis and so on. The 4 years is the starting point for seriousness, and the courts have warned against being too distracted by that sort of limited scenarios in which you can look away from the sentence. For instance, was there credit for a guilty plea, such that, as here, you need to judge it to be more serious than actually the sentence handed down was given, or their age. Anyway, but the fact that they have rehabilitated does not detract from that which got them within there in the first place. It would not be a relevant change of circumstance. It's to be expected. Where it's not present and they've gone on to reoffend and so on, yes, that will very much count against them. But to get brownie points and somehow dislodge or water down the public interest simply because you're no longer a risk is inconceivable, for whatever the theoretical relevance, that it is capable of in establishing very compelling circumstances over and above where otherwise there would not be. So it can be effectively kept alive such that we have cases such as this, which are nothing to do with the exceptions. It's simply just a lone male, say, as a theoretical possible, and they will seek to pursue their appeal on the basis that they have rehabilitated. And it would just essentially waste public authority, the courts, time.
So you're asking us to say that in no circumstances can rehabilitation be a ground for on its own for establishing very compelling circumstances. But, suppose it's rehabilitation plus something else.
In that scenario, it would be the something else which would have to be sufficient. It wouldn't be the additional present as a plus point of the rehabilitation.
Seems to me that this would be to set up technical rules. I mean, I quite understand what you're going to say on the merits, but it seems to me that to set up a rule, technical rule, wouldn't really help.
My Lord, I'm trying to put it so that it doesn't become a technical rule. It would simply essentially be saying that we agree with Mr. Tarbury, we cannot foresee circumstances in which the most rehabilitated offender satisfies the 117C6 test or because of that rehabilitation, which has returned them to a status quo, or avoid that sentence given the points we discussed in relation to RA. Alone, per se, we're not saying it's not theoretically possible, but and if then the some possible scenario that I presently can't envisage appears, then it may, and it's not been ruled out, and so ECHR certainly not been overturned. But before bringing appeals such as this, with Dr. Lakenby instructed over and over again to say he's a low risk, parties will consider seriously about whether that has any prospect alone of making any difference. And that would be a useful exercise for public resources and for clarity. And this court should be concerned with that. We see this judgment that we're about to look at on ground one is perhaps the best example you can see of a myopic focus on treating rehabilitation compliance as somehow sufficient. And of course, a more methodologically appropriate route, whether it's the balance sheet approach or something else, a clearer focus on the exceptions and whether there is an over and above presence, would perhaps have been sufficient and avoided the errors. Simply telling the First Tier Tribunal that it's incapable, subject to something we cannot foresee, of being sufficient would prevent this occurring in the first place. Otherwise it just becomes a case-by-case, reasons, relevant considerations. I don't think I can say any more on it. Idea. You have my submissions on it, and I'll turn to ground one.
Just going back to when you were talking about over and above,
Mm.
and going back to Yeltsin for a moment, in Justice Underhill's notes, note 9.
Can you remind me what page that's on?
Sorry, of course, 617. He says,
Yes.
now he's referring back, I think, to paragraph 57 at 612, or at least that's where we see the little 9 that takes us through to the note. And he says, at risk of not every case under subsection 6 will be an overlap case.
Mm-hmm.
It's hard to see that the over and above of any function in a case where the claimant's not relying on circumstances falling within either exception.
Yes.
Yeah. Well, I think,
we agreed, my lord.
Well, I think Lord Justice Underhill is, it's clear law
Yes.
that the exceptions are not exhausted of the kinds of
Exactly.
Yes.
very compelling circumstances.
You can have a foot in and a foot out, a complementary approach.
What we're talking about is they're more compelling
Yes.
than those circumstances.
Yes, the unduly element. It's hard to see if you don't meet the lower, how you can possibly establish the higher. It was a point I made in Gardinala in one of your judgments before you, that the court didn't accept my invitation to really develop and address that point, such that it would only become one way in which you could satisfy it, namely complementary, but not over and above. But again, it's another example of the ways in which the courts are essentially cautious about ruling things out because of potential relevance, potential ways in which, rather than going the final furlong and not just putting it in note number 9.
Yes, well, if you ask us to lay down absolute rules, you'll have quite a lot of resistance as you already have, I think.
Yes.
Generally,
Which is why I don't put it as an absolute rule.
Because as they say,
Yes.
it's all in the experience. And
Absolutely, and then the cases that allow that experience to change the law can come along and clarify it, and thankfully the common law helps us out like that. But we shouldn't be afraid at this juncture, where we haven't got those circumstances, of saying it as we see it now. So ground 1. I think the first point to pick up from reference submissions, and it's continues a theme or a character to ground 1 as written, as drafted as well, is that it's put in terms of a reasons challenge, or rather a defence of a decision that has found inadequate reasons. But hence you were taken to today a practice direction which summarises the law on sufficiency of reasons, and 1's put in terms of reasons. But as we see from Judge Jackson's decision, it is much more than that. If we go to her judgment, paragraph 23, page 66. This is the overall conclusion. So the first point is that, in the first sentence, that it's primarily about failure to take into account all relevant circumstances. The same sentence then adds, and failed to give adequate reasons as to why such weight was given to rehabilitation, that it, together with the passage of time, was sufficient to tip the balance in the appellant's favour. That is more failure to take into account. It's not simply you addressed it, you told us why rehabilitation was sufficient, plus the passage of time to tip the balance. It's the absence, it's the wholesale absence. So simply saying, making points appeals to the not being too interventionist when it comes to reasons. It does not, just sets the appeal ground off on the wrong footing. It was said that the relevant principle is that inixities to be avoided, the individual should be able to know why they won or lost. Well, we don't know from these reasons why the balance was said to have been tipped. For instance, we don't know why it was said that the exceptions aren't met and yet they are also at the same time exceeded with the over and above. We just don't know. That's not, there's a paucity or a lack of clarity as to reason. If I could take you to Yalcin again, it's at, we have a note of it now already, it's tab 30, this time to paragraph 19 on page 599. So between E and F, Justice Underhill summarising ECHR and Unueni, helpfully, is why I go to it for its helpful summary. Says, the important point is that what is involved is a broad, holistic assessment. That's the description of the 7C6 test. And that is the legal context for the finding by Judge Jackson that there was insufficient reasons. It's saying that in this broad, holistic assessment where everything has to be taken into account, whether it's balance sheet or otherwise, there's just key bits missing. So it's a misreading of the judgment to say our reasons don't have to be particularly, there's a high threshold rather to establish a reasons change. The next, you were taken to SC Jamaica and paragraph 111. If I could take you back there to it, it's tab 15, page 269. Essentially the same point. So 111 begins, the base NA Pakistan is correct. It follows that in cases where the two exceptions do not apply, a full proportionality assessment is required. And we are not given that by First Tier's judgment. At 110, we see why in SC Jamaica the First Tier decision was upheld. Final sentence of 1110. She did, well, I read in did, she carried out a full proportionality exercise conducted by reference to the very compelling circumstances over and above those described in exceptions 1 and 2. So SC Jamaica doesn't assist my learned friend because it's on that basis distinguishable, as well as confirming the legal standard that is not here met. The third point I want to come back on ground one is in relation to Dr. Lakenby. And the first point subsidiary to that my friend made was as to the tribunal having been entitled to reach the conclusion that it reached in relation to her evidence. But again, Judge Jackson didn't the errors of law found by Judge Jackson were not as to the conclusion reached or the weight attached. My Lord points to my friend with it. I don't think the respondent is disputing the quality of the report, say, or that it's in its own terms a good report, or it's not an error of fact challenge to the findings as to risk. There's no dispute there. So simply to say that the tribunal is entitled to reach the conclusions it reached vis-a-vis her report is by the by. It's not disputed by Judge Jackson. The next point was as to the quality of the report. As I say, irrelevant, not just for the respondent's notice point, but in terms of the errors of law found by Judge Jackson. He didn't disagree. And then the next point is particularly important to the extent that any of these issues as to risk reduction are relevant at all. is, well, her friend said that because of her earlier involvement, she was in a position to track the progress of the appellant because she did an earlier report on the 1st of June 2013. And that's in your bundle too, because of the unnecessary focus on the rehabilitation. But my response is that in that 2013 report, which was before the previous tribunal decision, which was on 3rd of July 2013, she had already found a low risk. See take you to her report. Supplementary bundle, page 221, 16.13. Sentence. And once you have that one noted,
Supplementary bundle page
221. 16.13, final sentence. The risk is currently assessed as low.
This is the time when he was released into open conditions.
I believe so, my lord, yes.
Possibly as a result of this report and other factors.
Yes.
Since the nods coming from the other side of the report.
Yes, I mean, the sort of adjacent points we made alongside all of this, which goes to both my submissions in response to ground one and the respondent's notes point, is that an individual who is, I mean, this is perhaps the only case, or not the only, a particularly good case for you to accept my primary point on the respondent's notice, because here you have this indefinite, this IPP sentence, i.e. the criminal justice machinery to control dangerous offenders, so as found by the Crown Court. Yeah. If that can't prevent reoffending and a low risk of, as found by Dr. Lakenby, nothing can. So it is a particularly good set of facts in which to say we don't see how this. Well, you have my primary submission, but the point is, despite that, he is commended for being low risk. And then secondly, 16.21 on 222. Risk of reoffending is currently low. Logical follow-up to this be risk of serious harm is also low. So already found low risk. So my learned friend's point about ability to track. There's nothing to track. The passage of time has occurred, but that surely can't be enough. The risk level hasn't changed.
I don't see where this is leading us. What did the Upper Tribunal judge say about Dr. Lakenby's report? In the error of law decision, okay, not mentioned, is it? And then the Upper Tribunal subsequently hears from her. You're in effect cross-examining Dr. Lakenby in her absence, or saying that her report shouldn't have attached much weight.
Well, perhaps I'm too slow to get to my point.
Yes.
I'm not disputing Lakenby. No, the Upper Tribunal didn't dispute Lakenby. The sole point is to the relevance of what she finds. And my learned friend puts the relevance in terms of her ability to track progress. And the point I was making is that doesn't work as a submission because the previous findings to low risk was made before the last tribunal. And as my learned friend says, the Diva Sealand principle, which First Tier acknowledged is binding, meant that you start from the previous tribunal's decision. So what was necessary, as my learned friend acknowledges, is to show that something had improved or changed since. Hence, my learned friend says, Mrs. Lackamby's great evidence to show something has, because she was involved then. But I'm saying that between the 2 points, A and B, there's no change. It remains just low risk. So if the first tier, first time round, to whom to whom, the tribunal's a person or in it, to whom Diva-Sealand applies, already dismissed the appeal where it was already low risk and there's no change, save for some years have passed. This is not good evidence of why, in this case, rehabilitation is some phenomenally important point capable of justifying the conclusion reached by the tribunal and showing that Judge Jackson was wrong to say that that was a flawed basis on which to find that the first tier had erred, failed to carry out a proper holistic proportionality assessment. Returning to the first tier judgment,
yes,
and what my learned friend said about that. So the first point I want to make is, not strictly speaking, a sort of carry on with these slightly point by point responses. It's just to make a general point now that we're looking at the judgment about why this was patently inadequate by the standards of ECHR, Yasin, Kapikanya. Findings and conclusions begin at paragraph 11, page 81 of the bundle. So paragraph 12, so 11, the exceptions aren't met. 12, if the appellant's offence was particularly serious. I would join with my lords, my ladies' observations as to that being wholly insufficient for the purposes of section 117C2, the seriousness of the importance of calibrating the seriousness of the offence. I mean, the label used for the subparagraph 6 offenders is very serious. So simply to say particularly serious is, strictly speaking, a misstatement of the statutory language. To say then in paragraph 12 still that this is reflected in the sentence he received, it's fine up to a point, but given that there was a discount for his being, for his guilty plea, it's inaccurate because you're supposed to look beyond the actual sentence handed down where that is a additional presence. Then the next point, and we begin to see the theme that the judge strikes. I note the offence was committed 16 years ago and he was released 7 years ago. And then paragraph 13, I find the passage of time reduces the weight of the public interest to some extent. Well, one, to what extent? You're supposed to be the first instance fact finder dealing in the question of weight on the different sides of the scale. Is it a lot? Is it not a lot? Is it none at all? Because it's just the passage of time, which surely doesn't give anyone credits. Paragraph 12, and this is to recall under findings and conclusions, not simply parties' cases, states the appellant claims he found himself in debt to unsavoury people. The appellant claims his offending behaviour was due to his age. Well, what do you find? Then 14, in line with Diva-Sealand, I use the appellant's previous appeal determination as my starting point. You have my submissions as to why that was effectively misapplied. That should have said, well, it was already found he was low risk by this amazing expert. what's changed applying diva sealan? Nothing except for the passage of time. Paragraph 15, according to the evidence of his appellant's witnesses, I mean, again, do you accept what the witnesses say? And if you do, why is it relevant that he's managed to live without reverting to crime? Surely that's to be expected. Paragraph 16, Lackenby, exemplary behaviour. If you can't do that when you're on an IPP, when can you? She notes that there have been no further offences or breaches. Is that relevant? It's not said as such. It's under findings and conclusions. But where's the attribution of weight, if any? 17, compliance was so impressive, really sort of getting going on the same point. 18, since release, limited money, family support, supports the risk assessment, which is low, and demonstrates his commitment to change. It already was, as I say. Skipping on to paragraph 20, again reference to, I attach weight to the evidence of Miss Lackenby, and in particular her assessment that the appellant is now a low risk of reoffending. Well, she'd said that 9 years earlier. To come out of the judgment then and to turn back to the manifest submissions, the next one was as to the legitimacy of starting with the public interest question and then considering whether there's something capable of outweighing it. That is a permissible approach, of course it is. But again, Judge Jackson's conclusion and findings of errors of law was not about the order in which the relevant points were taken. It's about the absences of the effectively mandatory considerations. Two more points on ground on this first tier judgment. The first, just further to what I referred to already, what my lords and lady referred to in terms of you may be just suggesting it, I'm certainly submitting it, inadequate weighing of the seriousness of the offence. So that's particularly important in a case such as this, as to why this case, again, is a particularly strong one for the submissions I'm making, is that the sentencing remarks refer to, for instance, sadistic violence and so on. And whilst the sort of colour of the sentencing remarks shouldn't be relevant to the objective exercise of 117C, what is relevant is length of sentence, of course, as I've said. Length of sentence is handed down, assessed on the basis of facts such as that, such as the one I've just highlighted. If you want the reference to it, it's in the supplementary bundle at page 312.
Well, I think you say that you've already drawn our attention to FTT's paragraph 12. The seriousness of the offence is dealt with in a single sentence, and then the rest of the whole of the rest of the paragraph is points in mitigation.
Yes.
Without which, presumably, the sentence would have been even longer.
Exactly. Exactly. Already taken into account, quite.
You would expect the FTT judge to have said the facts of the With the robbery convictions, perhaps the driving ones don't matter very much, but the facts of the index offence, the robbery convictions, were as follows. So it's not just serious offence in the sense of being over 4 years, it's very serious even within that.
Yes.
That's on one side of the, as Weston doesn't like the balance sheet, but anyway, Lord Thomas's balance sheet. On the other side, you have the following: rehabilitation, delay, he doesn't come within exceptions one or two. Is it nevertheless very compelling circumstances over and above the norm? You say that's the weighing exercise which should have been carried out, and it wasn't.
Broadly, yes, my lord. But I'm trying to be generous in saying that I don't say that there's anything wrong with, rather than say a balance sheet approach starting from. I mean, it maybe amount to the same thing ultimately.
Well, can I raise this?
Yes.
And this is really for both of you. This is an Article 8 case. And I, analytically, can easily see how positive good character, rehabilitation and all of that can have a very powerful effect in reducing the weight of the public interest on what you call Pillar 1. Although on the evidence in this case, it cannot ever eliminate it, because you can never say no risk. So if we're talking about risk to the public, you could bring that down very low by this saintly character. And I'm not talking about this individual, but just in this hypothetical case. For years, but where does it come in on, if we're doing this balance sheet exercise, how does this positive good character come in on the other side?
Doesn't.
Because the exceptions 1 and 2 are about the impact on private and family.
Yes, exactly.
Of the individual or their close relatives. So it seems to me there's a sort of anterior question. What's it doing on that side of the balance sheet? And that's a rhetorical question, because I don't have an answer. I'm not saying doesn't have a role, but there's a risk if you don't focus, as arguably the First Tier Tribunal did not, on the question of why is this an Article 8 case? Why is it very compelling in Article 8?
Yes.
And just say, well, these are very compelling circumstances. It's a splendid chap. We've got gold stars for his compliance with conditions and all the rest of it. I find that all very compelling evidence. That's a model, isn't it?
Yes, absolutely.
I'm not
You don't need a balance sheet for that. You just need 2 sets of scales.
What you need to do, I think, is to say, well, the weight of the public interest on the one side, on the facts of this case, is up, wherever it is, on the facts of the case. And what you're looking for is something on the other side that makes the interference with private or family life so very significant that it is more significant.
Exactly.
Isn't it as simple as that? I mean,
it's not. I don't know, but it depends what it is in that proposition, that question.
Something that counts as an Article 8 consideration.
That certainly is a further additional flaw.
Has whatever weight. It has more than the weight that you've attributed to the public interest.
Exactly. That's a slightly distinct point, and it's completely valid, and it's one that I rely on. That whatever you think about rehabilitation and its potential great weight that it can have when calibrating the public interest or relevance to the public interest, it does nothing to establish any level of interference in the ways formulated by the exceptions or in broader Article 8 jurisprudence at all. So on ground 1, the appeal to the validity of the justification for accepting Lackenby's evidence or whatever else just does not rescue the judgment from its utter failure to consider whether, irrespective of any rehabilitation, there was unduly harsh circumstances or anything else. In addition to what I'm saying about, in fact, rehabilitation does nothing to materially lower the public interest anyway. turning to the upper tiers judgment, which we've already touched on a bit, obviously. The first points made were in relation to the Upper Tribunal's task, reference to Warby, Deutsche Bank, proposition. There was authority within Deutsche Bank for the proposition that the deference, if you like, margin of appreciation to be afforded by the appellate court. It's not just on factual findings, but also evaluation. But as I've said a number of times already, none of what Judge Jackson found was to criticise the conclusion on the evaluative exercise performed and reached. It wasn't a sort of rationality finding. This was outside of the conclusions you could have reached. So does not assist the appellant. The next point made was that the first tier, contrary to, as a defence of the first tier, could be taken to have been aware of the significance of the offence, despite the absence of the sort of things we were just saying are missing. Why that's particularly insufficient and is a point that the Judge Jackson's entitled to take, I'm entitled to make, despite the principles in ECHR at 72 from AM Somalia, etc., and Deutsche Bank and so on, is that awareness isn't sufficient. This is a exercise, a statutory exercise in which the relevant considerations have to be put in the mix positively, weighed, and weighed against each other, most importantly. So awareness doesn't get you home, doesn't get you anywhere, even if you assume. And then, which goes to the next point, criticised applying those principles on the approach of the upper tier, namely that the first tier should be treated as knowing all the authorities. Why it was relevant for Judge Jackson to say there's no reference to ECHR, this sort of almost statutory level of importance principle now for this area, is that it prevents the upper tier applying a benefit of the doubt approach, so that even if there's a sort of missing chunk of the ECHR analysis, they can be treated as knowing what they're up to, say. That's why it's relevant to set out these points. It's a bit like the methodological point about the starting point, the balance sheet. Taking that approach allows those who then review their decision, the upper tier say, to say, well, it's engaged at that point. Without that, none of those beneficences can be afforded. As to the balance sheet would double count, it really wouldn't. I mean, many of the authorities in this area are about the necessity in reasons terms of reciting the findings made on the exceptions. But the point here is simply that it is not only is it permissible to consider it, and it's useful when it's done for reasons I've given, namely that how can the relative question that is inherent in over and above be considered without having regard at the 1176 stage to what the position is in relation to those exceptions. My Lord Justice Warby's point about rehabilitation says nothing about unduly harsh or difficulty reintegrating or whatever. I mean, had there been reference back, not that there was much to refer back to because it's pretty thin analysis of the exceptions too, would perhaps have assisted in making conclusions on the 1176 conclusion. In fact, it makes the task, much as it's a broad proportionality holistic assessment, that much easier, because you simply load into the assessment what you found already and see if there's something more complementary outside. You see here the error where that is not done. The last point I'll just come back on is said that only the absence of offending is not to be given great weight rather than rehabilitation evidence positively. On that, could I take you to HA 1
We've been over this
you-
paragraph.
you've seen it many times. It's the point simply, as you had with my respondents' notice submissions, is that it's both. It's both. It's not just can't see how you give it much weight where there's mere absence of reoffending. It's actually also where there's positive evidence of rehab.
Yes.
Turning to ground 1.3, remittal versus retention and remaking. The general point is this: there is a presumption, both within 7.2 and reiterated and underlined at 7.3 of that practice direction, that the tribunal will hang on to the appeal. And in AEB, on which my learned friend relies, at paragraph 14, quoting Sir Ernest Ryder and J.A. Garner, it was said that where you're acting in line with the presumption rather than going against the grain, there's no need to give detailed reasons about why you're not doing the normal thing. It's not been said that the appellant requested remittal and a departure from the presumption. My Lord Justice Bean's point about was it, well, not, I don't think you were putting it as sort of necessary in the law, but simply trying to sort of understand the submission being made as to whether it should have been canvassed with the parties as to whether to go against that. Well, the point is, when parties make appeals or make submissions as to what they think should happen in the appeal, they readily state what they think should happen vis-a-vis disposal. So it's not the only opportunity to address this question, which would have been as known to the parties, or rather their lawyers, as the judge, that this is the presumption. They would have known that that's the position. If they wanted something else, they could have said so. The next point is to the scope of the exceptions and really why they weren't present here. Judge Jackson was entitled to not treat them as found as present here. Fairness, very clearly not in issue. The second one was as to the nature or extent of any judicial fact-finding which is necessary. So my learned friend says that given that this was upon remaking set down for a day's hearing, 4 witnesses, that is an extent that engaged the exception. That is a misreading in respect of 7.2 B, because it is the nature of remaking that it becomes a fact-finding exercise, albeit by the upper tier, not the first tier. So it would mean that in every case, having said this needs to be remade, it needed to be remitted, despite this presumption. Rather, what 7.2 B is referring to is something narrower. It's talking about error of fact in the E and Secretary of State's sense, which we see from an authority referred to by my skeleton, but if I could take you to it, it's Begum at paragraph 37. Sorry, paragraph 37, tab 37, I hope I said.
This is a case where it was conceded the judge hadn't read 2 of the 3 letters that were submitted
Yes.
late on.
Which is a fairness issue, rather than error of fact, but the tribunal, hopefully being presidential, as my own friend says, give wider guidance.
What paragraph?
It's paragraphs 15 and 16. 17. You perhaps read those to yourselves, if you haven't seen them already, and I'll make my next submission. So paragraph 17 on top of 777, they say that that's also engaged. They say there was a mistake as to the availability of evidence on that matter, and it's uncontentious that the letters were made available to the judge. So that is a classic E in the Secretary of State scenario. It's incontrovertible fact, and there was a mistake as to it. It's not the evaluative question of, are there very compelling circumstances over and above the exception? That is insufficient, however many witnesses are called at the remaking by the tribunal to trigger the first exception in 7.2. Those are all my submissions on ground one. Unless subject to anything you'd like me to address. Then ground two. It said that there are two very significant errors. The first was about delay. As I said, the perhaps best authority here is Bingham's judgment in EB Kosovo, which is tab 9. If I could take you to paragraph 16 on page 99. His Lordship said, delay may be relevant, thirdly, in reducing the weight otherwise to be accorded to the requirements of firm and fair immigration control if the delay is shown to be the result of a dysfunctional system which yields unpredictable, inconsistent and unfair outcomes. And he then set out how the appellant's cousin was given a arbitrarily very distinct decision and refers to other authorities on wildly discrepant outcomes in the same circumstance, and says in the same paragraph, page 100, a system so operating cannot be said to be predictable, consistent and fair as between one applicant and another, from Huang. That's not alleged nor the case in this case.
Can I ask, as we're on the subject of delay, why was there no decision between 2015 and 2021?
Well, could I take you in relation to that to the decision, or the original decision, to refuse the human rights claim in your call bundle at 85. Which contains what I would recommend as the best chronology before you for its completeness. As you expect from the Home Office themselves. And we see the deportation order, from which point, if you like, time's running on delay, paragraph 19, page 86. And then from there, I won't go through it all, but to paragraph 43, and then ultimately this decision itself, we see there is a pause in the challenges to the respondent's decisions by the appellant, pursuant by litigation or further submissions, punctuated by expeditious steps, see paragraph 21 and 33, by the Home Office by the respondent, the Secretary of State, to enable the return in terms of obtaining a ETD for return to Rwanda and engagement with the Rwandan embassy. So, and my lord, you raised this. So delay is relevant when some of it may be caused by the individual in question.
Yeah.
That's what this is. That's what happened here.
as we're in the, I hesitate to get to my feet, as we're in this decision, I'm wondering if it's worthwhile going to paragraph 100 of that decision, in particular paragraph 101.
I'm sure we'll get there.
Yes, but as I've just shown, it's not correct to say nothing happened. Nothing happened in terms of pursuing and actioning a deportation, but there was a hive of activity in the ancillary matters of challenging that and dealing with all sorts of other legal challenges by the appellant.
Well, of course, it's not every appellant who ends up in the Supreme Court, but that was on the conditions of bail, or it was not on the question of whether he could be deported at all.
And his ability to do voluntary work, I believe. But I think it cannot be said that it's, I mean, it might have been somewhat ensconced by the Supreme Court if, whilst the individual's trying to bring his appeal before them, he's being the respondent seeking to deport him.
Well, except at 101, do represent said it's not considered to be a barrier to your removal to deportation while waiting for the Supreme Court outcome.
They might have said that, but I'm not sure that's necessarily the case.
Is there any evidence that that's why they didn't pursue it, or is this just?
Those are purely my inferences, my lady. But insofar as the point's made as to delay, I am submitting that this chronology doesn't represent delay.
It does. It represents massive delay in relation to deportation.
My lady,
they managed to get from 0 to the end with the Supreme Court in length of time. Nothing was done by the Home Office in relation to deportation.
Well, if we look at some of the chronology as to why I would say that, I mean, insofar as a deportation order in 2013 that is not then carried out is always delay, I would have to accept that, because ultimately that is delay, isn't it? It's not been implemented. But if delay means you're sitting on your hands in terms of dealing with what's in front of you in terms of legal challenges and enabling removal, I submit that that's not how this should be characterised, and that's presumably an objective question and not to be determined by what's said later on in the decision letter. So for instance, paragraph 21, forwarding of biodata details to enable removal, that's related to delay. Paragraph 24 in 2015, a request to revoke the deportation order. That's, I mean,
2015.
Yes. 2016, a further ETD application sent to Rwanda.
Well, I have your point.
There was item 36. March 2016, your legal representatives launched a judicial review. Do we know about what?
It says at 37, the Lord was renewed.
It rather looks as though it was the case which ended up in the Supreme Court.
Yes. I mean, I simply don't have instructions as to whether it was legally possible, whether there was advice at the time by those involved in the proceedings that ended up in the Supreme Court as to whether it would it's not viable, doable, feasible to remove someone whilst those proceedings are going on. I can obtain those instructions if it assists, but I would simply submit that that is not the sort of situation where the EB Kosovo is concerned with, where the individual is left in a precarious situation, within that develops family life relationships, deepens private life matrix networks, such that subsequent rupture of the same has to be one has to wonder, require a greater public interest in order to do so, say, not least because there's no reliance on the same here. But,
I may not take it any further, but I can't help noting at 41 that on the 7th of May, before the Supreme Court hearing actually took place, a letter was sent vis-à-vis the deportation asking for the appellant to bring his case up to date given the age of the submissions, which does rather seem to suggest that they weren't interested in the Supreme Court, they just hadn't got around to doing it.
Again, I don't know, it could also be because that they were on the cusp of the very end of it, namely the Supreme Court hearing, which was 3 days later, and they thought, right, now we better get round to the thing that's been put on hold. I don't know, lady, I simply don't know. I would submit that it's not the mischief that E.B. Kosovo was concerned with. I would also say that the judgment, as my supplementary skeleton said, addressed delay and even essentially found for the appellant on it by saying, yes, I see that I should attach weight to that. So it's a sort of academic point. It's like, what more do you want? I think it was put in terms of, given that you won on that, in terms of, oh, it shouldn't be about I attach weight to that, rather its relevance is to diminish the public interest. It's simply the flip side of the same thing.
Yes.
So I would say if the court is minded, as perhaps is being intimated, to find that there was delay here, I'm sorry, I haven't found out as to why.
You're going to say it wasn't in the third EB Kosovo category?
It certainly wasn't in the third EB category.
But that's the one you were taking to paragraph 16.
Yes.
Dysfunctional system.
Paragraph 15, the one before that, is the one I've just addressed as well, my lord, in terms of the precarious situation which the individual is left.
Yes, but that's not the submission against you, I hope. The submission was that delay goes to reduce the public interest in enforcing immigration control. So
yes, which is paragraph 16.
Is it in that kind of case?
Yes, exactly. So, exactly, Lord. So, insofar as that submission is properly construed as being Lord Bingham's third category, if you like, at paragraph 16, it falls short of what he had in mind as being necessary, making the delay relevant in that sense.
Yes, well, you say it's not unreasonable behaviour on the part of the Home Office. On the other hand, you have to accept it's not a case, as some are, where the appellant disappears and goes off the radar for several years.
No, it's not that level of sort of contributory delay, if you like. But just for completeness, to the extent that there may be some other ways in which EB Kosovo and delay is relevant. So paragraph 14 is the point about whether within the delay the relationships are strengthened, etc. Not engaged here. And then the point at 15, the second one, lastly, is in terms of precariousness. So where someone starts a new Article 8 relationship, etc., whilst in a state of precariousness, generally little weight is attached to that. But if they've done so because they've simply been in the limbo of delay, then that's not the case. That's what paragraph 15 is. Again, not relevant here. So the delay point really goes nowhere. None of the ways in which it can be relevant are engaged, and in any event, Judge Mandalia accepts and chalks it up in the appellant's favour. And then just remembering Lamfred's short points after lunch with reference to A.H. Sudan, the full list of the relevant principles for the appellate court or tribunal looking at the first instance fact-finding decision is, as I say, in ECHR 72. which I won't take you to, but you'll have your note on it. On ground 2, that becomes relevant to the challenge to Judge Mandalia's decision. And one of the reasons why Learned Friend's suggested approach early this morning, a long time ago, of staging your analysis so that if you're with her on ground 1, you deliberate and decide and then don't need to consider ground 2 rather than all in one go, is not to be recommended in a case like this, is because here, by seeing the second determination, you have a very useful illustration of how it's done and of a application of 117C6. I'm not going to take you to Mandalia's judgment, but that properly weighs the relevant factors and can be starkly contrasted with what you see vis-a-vis the first tier as we considered on ground 1. And I would say that applying paragraph 72 of HA, there's no basis for this court to find that, to set it aside. And if I can help you with anything, panel, judges, my lords.
Thank you very much, Mr. Tamori, Mr. Weston. As ever, no need to repeat anything, but anything
strenuously avoid
yes.
doing that. This is a straightforward case, in my respectful submission. There's no big law here. The question is, was the Upper Tribunal entitled to set aside this judge's determination?
Yeah.
This judge's determination, we say, was consistent with the case law in HA Iraq, and the Upper Tribunal, on the application of the Secretary of State, on the Secretary of State's grounds, decided that it wasn't consistent with HA Iraq. In my respectful submission, there is no basis, nor should the court indulge in a speculation, almost drafting litigation on the hoof, as to some additional aspect of HA Iraq which was left incomplete by their lordships when they made their judgment, or indeed turned to similar issues in SC Jamaica. In my respectful submission, my learned friend's ingenious and skillful submissions are envelope pushing and not matters which this court needs to be concerned about in this appeal. So that's dealing with the respondent's notice. I wasn't intending to add anything further unless the court felt that I should. Just coming back on a couple of points. My learned friend said that the submission I made about the particular value of the series of reports that the First Tier Tribunal had before it, in this case from Ms. Lackenby, was badly made because the original 2013 report said that he was of low risk and so there was no change. That's absolutely, reading the 2 point reports side by side, the court can quite clearly see that's not the case. I'll just give an indication of the pages at 223 in this page 223 in the supplementary bundle, paragraph 16 of the initial assessment of Dr. Lackenby. She says that the assessment concurs with the assessment of the offender manager and offender supervisor that within the UK the risk Mr. Majera poses can be managed in open conditions. That's what she was addressing her report to. Indeed, it's my opinion that the risk Mr. Majera poses can be managed in the community. However, I'm aware of the potential benefits to Mr. Majera being tested in open conditions. Then she says, importantly, at the end of that paragraph, my assessment is such that Majera's risk can be safely managed in the UK. However, the risk he poses to others cannot be safely managed in Rwanda. It's a, in my respectful submission, accurate reflection of what the Ministry of Justice offender manager's position was at the time, with which he concurs. And it was targeted to the measures that would be, in her view, appropriate to manage the risk posed by Mr. Majera in open conditions.
You said you were going to draw contrast with the later
Yes.
assessment.
By contrast, I also, yes, and there's another point I'd make. By contrast with the 2022 report, which is the one that was before the First Tier Tribunal, there has been a period out in the community, a significant period in the community by that time, and she is commenting on making her assessment on the basis of his being tested both in open conditions and in the community, and is reaching views. But it's important to recall that she makes the point, and I took the court to it at 2.4 in the 22 report, page 241, that there's no risk lower than low.
Yeah.
What she does is puts some more precision on her assessment of risk, and she expresses herself with a high degree of confidence.
Yes. You can see that. There's a difference between 2013, I'm telling you he's low risk,
yes,
and 9 years later, I told you he was low. 8 years later, I told you he was low risk.
Yes,
Yep.
not only that, but there are various exceptional factors. She uses the word exceptional, which to which the First Tier Tribunal obviously attached weight. And in my respectful submission, the quality of that report is highly unusual, and its contents are expressed in the kinds of certainties that one very rarely sees in assessments of this kind, and that's impressive. So just when Mr. Mandalia says towards the end of his wrapping up his assessment, forgive me. I don't know how I managed to do that, but I've managed to, oh yes, at paragraph 67, sorry, at paragraph 68, he says, in reaching my decision, I've also had regard to the fact he talks about the rehabilitation, and the appellant now accepts responsibility for his actions. And the evidence of Ms. Lackenby that the appellant's compliance since his release is relatively uncommon. So in my respectful submission, that's to somewhat downplay what she's actually saying in those two, indeed three by that time reports. So we dispute the Secretary of State's characterisation of those, of the value of those reports. I wanted to come back, if I may, just briefly on my Lord Justice Warby's concern about what role rehabilitation plays in the scheme of things. And regrettably, I have to take the court back to the Balti factors, because they do, and the passage of time, they are quite comprehensive factors, which the court accepts are material, and we see them.
Do you accept that HA Iraq paragraph 58, including the approval of Lord Justice Underhill's observations, are a correct statement of the law? Mr. Tabori was trying to push us in one direction from there, and perhaps you're going to try and push us in another direction, but it seems to me that's the current ipsissima verba from the highest court in the land.
I agree, but again, it's always dangerous, isn't it, to harness on one particular paragraph. That paragraph makes sense because fundamentally you can't tie a judge's hands. If the judge is having regard to multi-factors, you can't tie a judge's hands about the weight that's attached to those factors. And that's reiterated everywhere. And it's quite clear that the multi-factors are set out in ECHR at paragraph 51. I'm not going to take the court through them. They're all there, and they include things like time elapsed since the offence was committed.
Well, I wasn't, to be clear, I wasn't suggesting that we should reconsider what the Supreme Court had said in the SK draft at all. Just trying to get my head around where in the analysis rehabilitation comes in. I don't think there's any dispute between you that it can be relevant.
Yes.
You're only on the respondent's notice. But my question is, does it make the interference with the Article 8 rights worse, that this is a good person, or does it only go to reduce the public interest in ensuring that dangerous people are sent back to where they came from? That's putting it very bluntly, but that's really up the question. Because that's what this is all about. Sending someone to Rwanda is an interference with their private life.
Agreed.
On the findings of the redetermination, that private life is minimal. No findings about in the First Tier Tribunal decision at all. So the question then is, does the good character shown by rehabilitation and positive life in the community make it worse?
Right.
Or does it just mean that the first pillar of the public interest has less weight? It may not matter, but it seems to me it's a systematic approach to the analysis.
The court at paragraph 58 is drawing a distinction between the mere absence of reoffending and rehabilitation such that there's a reduction in risk of reoffending. The aspect of rehabilitation which is material to the public interest in deportation, the protection of the public from further offending, relates to that element of rehabilitation, i.e. where there is evidence, rather than using the sort of composite term of rehabilitation, where there is evidence of risk reduction. It is that element of rehabilitation which is relevant to the protection of the public aspect of the public interest. However, there are other aspects of rehabilitation, such as positive behaviours, development of positive behaviours, and for instance, I'll give you an example. In the Lackenby report, she pointed out, and I've got the page reference here, that he had been identified by the probation service as a person who it would be appropriate for him to act as a mentor for young people. Now that is an assessment that was made by the probation services. The documents are in the bundle and the references are in the bundle. There is no specific link in that element of rehabilitation between with risk reduction. It's not an obvious reason that somebody who would be a football coach or a mentor would necessarily, I'm sure there are football coaches that commit crimes, but the point here is that there are aspects of rehabilitation which go beyond the mere absence of offending and the risk of reoffending. This character, this person, was a success story for the probation service. The rehabilitation purposes, we don't need to go into them, the court will be familiar with them, but the rehabilitation purposes aren't just about the protection of the public, they are also about making a citizen who can contribute and be a positive aspect. And that success is part of what rehabilitation means. It's something that the professionals involved in that process take very seriously indeed. It doesn't answer the whole point to describe rehabilitation. That's why rehabilitation and the right to rehabilitation is recognised in Article 8. It's a part of your private life. It's a part of your identity. It's not just about reoffending, and it's not just about the absence of offending. And for all those reasons, yes, I agree, paragraph 58 is good as far as it goes, but it's not the whole story about why rehabilitation is a positive, can be a positive factor. I don't know if that answers my
No, that's very helpful. Thank you.
So you say it's capable of going to both aspects?
Yes, indeed.
Yeah.
Goes.
That's very helpful.
May I just check my quick note?
Yes, of course.
Yes, I accept, just turning to the Upper Tribunal's reasoning, I accept that part of the criticism of the First Tier Tribunal is a sort of a process rationality point about not taking things into account. And but the only thing that it's not taken into account in the reasoning of the Upper Tribunal.
This is in Mandali.
Yeah, no, this is, sorry, this is in
Jackson.
Jackson. I'm still in Jackson. Forgive me, I should have made that clear. I'm responding to my learned friend's submission about this not just being a reasons complaint. So the only failure to take relevant matters into account is the reference to, is the complaint that there wasn't sufficient reference made to the detail of the criminal offending. What's quite clear, and I can't put it any higher than I have, is that the judge was treating what the First Tier Tribunal had said as being her starting point, and for that reason didn't go back into the sentencing remarks of the judge and what have you, because her essential question was, well, this is where the tribunal started in 2013. What's happened since? What have we got now? What's the picture now? And that was that's a legitimate way forward in my respectful submission, having regard to the Deverseelan principle which she properly applied. Those are my submissions. I know that Ms. Derio did want to come back briefly on ground 1-3. If the court's, I'm happy to deal with it if the court would rather, or if the court is happy to hear from Ms. Derio.
All right, Ms. Derio.
Thank you very much. I'll be very quick. I'm very conscious of the time. And there are 2 points to be made without repeating too much. And I took the court to it very briefly, but that is looking at AEB, which reference again was made by my learned friend. This is at page 542 at tab 28 and paragraph 9. Just to put emphasis on paragraph 9 and what the requirement upon the Upper Tribunal was, what the task was required of Upper Tribunal Judge Jackson. And this is looking at where de novo findings were necessary or not. The test under paragraph 7.2b is relatively stringent. The Upper Tribunal is required to have regard to the overriding objective before reaching a conclusion that the nature or extent of any necessary judicial fact-finding is such that it's appropriate to remit the case to the FTT. That is entirely absent from the decision. Perhaps might be repeating the point that I've made already, but that's important just to highlight again. And the second point to make is with regards to AEB, which you were taken to, Begum, which you were taken to by my friend, my learned friend. This is at tab 37, very quickly, or page 778 if you have the electronic bundle in front of you. And there is a distinction to be made between what the Upper Tribunal did in Begum and what the Upper Tribunal didn't do in this case. So if she had followed the similar path or had engaged in similar considerations in Begum, then there would be no argument with regards to it. But again, it's totally absent from it. So if we look at paragraph 23, you'll see what the tribunal found there when they were able to make the decision as to why it should remain in the Upper Tribunal.
Yeah, they found that those two letters only went to one point in the case.
Exactly, and the difference here is Upper Tribunal Judge Jackson finds that actually the assessment was at the heart of the case and nothing could stand, whereas you'll see here where it says the other strands of that proportionality assessment were fairly and effectively considered and resolved by him. This consideration bears upon both 7.2a and 7.2b. The reason why I highlight that and I make that distinction is because effectively it was a discrete part that needs to be considered, whereas that didn't exist in Upper Tribunal Judge Jackson.
And the thing against you there is that if we accept the Secretary of State's analysis, the problem with the First Tier Tribunal decision here was there were things it didn't deal with. It dealt with everything and got one thing wrong, so it's a completely different kind of case.
With the court's permission, just one observation. Yes, this isn't a case where somebody lost their first instance appeal because of an unfairness. But what's the logic in putting a person who won their first instance appeal in a worse position than somebody who lost?
That's a different point.
Yes, it is a different point, but
your point about it is about depriving the litigant of another go.
Yeah, it's about the loss of the two-tier system, and if one restricted the analysis to cases in which a person had lost their appeal because of an unfairness or a failure to deal with an issue, you'd be putting somebody who'd won their first instance appeal in a worse position for no logical reason. Those are my submissions.
Thank you very much. And thanks to all three of you for your submissions. We'll reserve judgment. Council may what I'm going to say next, but I still have to say it in every case. We will send out a draft judgment, draft not in the sense that any point is sent out for re-argument, draft only in the sense that we ask for any obvious factual errors such as dates and so on, with typos to be corrected. Then we'll hand down the judgment formally. In the interval between the draft and the hand down, the contents of the judgment may be disclosed, of course, to the appellant and to those in the Home Office who need to know about it, but not publicised until the public judgment is put on the National Archive and so forth. Thank you all very much for your assistance.
All rise if able.